The impact of federal legislation on HRM managing HR effectively is a complex challenge for managers. For one thing, the legal and regulatory environment is constantly changing, and HR managers have to stay on top of issues that might have legal consequences. It is critically important that managers know and apply a variety of federal laws that have been passed to ensure equal employment opportunity, EEO. Some of the most significant legislation and executive orders are summarized in Exhibit 12.4. The point of the laws is to stop discriminatory practices that are unfair to specific groups and to define enforcement agencies for these laws. EEO legislation attempts to balance the pay given to men and women, provide employment opportunities without regard to race, religion, national origin, and gender, ensure fair treatment for employees of all ages, and avoid discrimination against disabled individuals. The Equal Employment Opportunity Commission, EEOC, created by the Civil Rights Act of 1964, initiates investigations in response to complaints concerning discrimination. Discrimination occurs when hiring and promotion decisions are made based on criteria that are not job relevant. For example, refusing to hire a black applicant for a job that he is qualified to fill and paying a woman a lower wage than a man for the same work are discriminatory acts. When discrimination is found, remedies include providing back pay and taking affirmative action. Affirmative action requires that an employer take positive steps to guarantee equal employment opportunities for people within protected groups. Failure to comply with EEO legislation can result in substantial fines and penalties for employers. Suits for discriminatory practices can cover a broad range of employee complaints. One issue of growing concern is sexual harassment, which is also a violation of Title VII of the Civil Rights Act. The EEOC guidelines specify that behavior such as unwelcome advances, requests for sexual favors, and other verbal and physical conduct of a sexual nature becomes sexual harassment when submission to the conduct is tied to continued employment or advancement, or when the behavior creates an intimidating, hostile, or offensive work environment. 18 changes in the workplace have brought about shifts in the types of complaints being seen. Complaints of sexual harassment by men against both male and female bosses, for example, increased about 5% between 1997 and 2010. In addition, there are fewer complaints related to blatant harassment and more related to bosses who make sexually charged comments and send inappropriate email or text messages. 19 sexual harassment will be discussed in more detail in Chapter 13. Exhibit 12.4 also lists major federal laws related to compensation and benefits and health and safety issues. This is only a sampling of the federal laws that HR managers must know and understand. In addition, many states and municipalities have their own laws that relate to HR issues. California, for example, requires that companies with 50 or more employees provide sexual harassment training for all employees every 2 years. 20. The scope of HR legislation is increasing at federal, state, and municipal levels. In addition, social and technological changes bring new legal challenges. The National Labor Relations Board, NLRB, recently filed suit on behalf of Dawn Marie Souza, who was fired because of a comment she made on Facebook. The NLRB's first, but likely not last, case involving a firing related to social media. 21. As illustrated by the example about Amazon in the chapter opener, companies operating internationally also have to be aware of laws related to HRM in the various countries in which they do business.